This board is required to follow the statutes as Mr. Yao has correctly pointed out regarding this issue. I'll touch on one thing that will become apparent later in my ruling, but that TCA 3911-402 deals with criminal responsibility for the conduct of another. There's no question that evidence is not that Ms. Castro-Miles actually pulled the trigger and fired the weapon that cost Deputy Baker his life. So the question becomes whether or not there was evidence of criminal responsibility for another under the statute. The second part of that statute says acting with intent to promote or to assist the commission of the offense or to benefit from the proceeds or result of the offense. The person solicits, directs, aids, or attempts to aid another person to commit the offense. That becomes important because when we're looking at the factors that have been brought out regarding the bail, one of the factors, of course, is the likelihood of conviction of the strength of the case, and that has been a great deal of today's hearing has been devoted to the strength of the case. So when I look then at the evidence before me that has been presented at this hearing, and considering 4011-118 of the Tennessee Code, which are the factors that I'm required to consider in a bail bond setting an amount, I would point out that I'm required by statute to set a bond because it is a non-capital offense at this point in time. Mr. Yao correctly pointed out that in a capital case, the defendant could be held without bond. In any case in which there is not a capital offense, then a bond must be set. The factors are, number one, the defendant's length of residence in the community. The evidence before me is that she has lived here for a couple of years. She has lived in the general area of vicinity, I suppose you could call Russellville, for 7 years. Her length of the residence in the community is not excessive. She's not a lifelong resident. The length of the residence in the community, I find, to be a factor that would not be in her favor. It is a fairly short residence, and she has, by the proof, been a fairly transient individual over the years. Her employment status, the history of financial condition, her employment status is that she's always worked. Her daughter testified that she has repetitively had jobs and has been and I think the other lady that was here that testified, Ms. Rupp, testified that she had worked. So I find that to be in her favor. Family ties and relationships. Her daughter certainly is an impressive young woman. I have no doubt that she would like to try to help her mother and so forth. Her daughter and she have a good tie, a good relationship. However, her daughter was living in Canada at the time and on the cusp of becoming a Canadian citizen, if I understand it, or at least getting a permanent visa, a green card, or whatever they have in Canada to be able to live there with a fiance at the point in time when this occurred. Certainly there's some indication that if she's living with her mother lives with her, then her daughter's connections to this area are not deeply rooted. She moved back here to Clarksville solely because of the trouble that her mother became involved in. The other family ties and relationships that I've heard today, I've observed clearly the testimony of Mr. Miles and his demeanor on the stand and his attitude during the hearing, and what I find is that Mr. Miles' attitude in particular does not impress me as being someone who cares much about the requirements of the courts, and basically he's the one who helped Ms. Castro-Miles in missing a court date in Springfield because they made an informed decision to just go on and do something other than appear in court. If, as she says, I'll do with that in a moment, the deal of her failure to appear, but her family ties and relationships are not very strong if she has been involved with Mr. Wiggins within a month of having separated from her husband, who went off to Kentucky to try to find a job. Her reputation, character, and mental condition, the reputation that's been introduced was all of which was apparently before the May episode occurred, and clearly she may have done many good things regarding animals. I wish she had been working with animals in May of 2018 instead of being with Mr. Wiggins. But the fact of the matter is that those facts do weigh in her favor. But I've observed her testimony today, her attitude and demeanor from the witness stand when she's here today asking to be given a bond on the most serious type of offense that we have on our books, first-degree murder, indicates to me that she is a volatile personality, and that goes to her character and her mental condition. Her prior criminal record, the record of appearance at court proceedings, clearly indicates that she has made intentional, purposeful decisions to fail to appear on at least 2 different occasions. But if you look at what she lost her license for, she lost her license for not paying a ticket. So we've got a charge of just a traffic ticket that she could have adhered to or paid, and that would have kept her license. She lost her license. She always had an excuse for why she lost her license. That supposedly it wasn't her fault. Then the next thing that happens is she gets charged with failure to appear in Springfield and makes an intentional decision not to appear, and they move away, and so she neglects that. Prior to that, in 2007, she was charged by the Border Patrol with a crime of possession. She's given us an excuse as to that. But the fact of the matter, had she shown up on either of those, she might have been able to defeat those charges. But she chose not to. She chose to fail to appear on those charges. And my question to Mr. Yao, and I apologize to him, it was unfair for me to interrupt him and pose that type of question. But the question that comes to my mind, and is very clear, is that if she made an intentional and purposeful decision not to appear on 2 counts where she potentially had possible defenses to, that were only misdemeanors, and then she made that decision not to appear, then how much greater would the incentive be to not to appear on a charge that is as serious as this one is, that faces a lifetime in prison? And for that reason, I've placed great emphasis on, Mr. Yao may say there are only 2 things, the failure to appear is the only one of these factors. I think it is the most important factor in setting an amount of a bond that would be appropriate. Her prior criminal record, she doesn't have an extensive prior criminal record. Her record of appearance is terrible because of the fact that she's, in my opinion, just repetitively failed to appear and make purposeful decisions not to appear. The nature of the offense, apparent probability of conviction or likely sentence, there's been a lot of time spent on that. As I've said, that becomes a jury question. The jury will have to decide whether or not her involvement in this federal drug deal, and whether or not that rises to the level of her having, after that, reported Mr. Wiggins as having stolen her car, and then having turned around and reconciled with him, and then having allowed him to drive her car. I have no proof that she allowed it. I have no proof other than her statement that she was his puppet. That indicates that he forced her, or forcibly required her to assist him. But if she was in the car and knew that he had made that statement, as was testified to, that he was not going to go back to prison, that he would smoke anyone trying to arrest him, and she allowed him to drive her car around, having reported it stolen, clearly would be an indication that she might think that some law enforcement person was going to come looking for the car that she had reported stolen. That becomes a jury question as to whether or not her actions, or lack of action, rises to the level. Certainly there appears to me to be sufficient evidence in this record to show the encouragement and aiding by allowing him to use her vehicle sufficient to make that a factor that would weigh against her in this bond hearing. The identity of responsible members of the community who will vouch for her, as I said, Ms. Rep testified for and is vouched for her, and her daughter, who is, I believe, an impressive young lady, both vouched for her, so that's a factor in her favor. Other factors indicating her ties to the community are bearing on her risk. Again, that I think goes again to when I consider the past and I consider the fact that she's made intentional decisions to simply avoid appearing in court on misdemeanor charges. And then I observe her in the witness stand today and her attitude towards this hearing and this situation. It's my opinion that that is a factor that weighs against certainly a low bond in this matter. This is, if she is convicted, she faces life in prison. It gives her greater incentive to leave as she has done in other cases. So I have set the bond at $750,000. That will be the amount of the appearance bond. Based upon that fact, that concludes this hearing for today. Because of the fact that we're near the lunch hour and we have other matters that I need to attend to, I'm going to go ahead and take our lunch recess now. We will reconvene at 1 o'clock to take up the other matter.